explain why we started working on the code. Meanwhile, I would like to tell you about the process of working on that code, when we started and what was the methodology of our activity. First of all, we created the working group. It included representatives of the so-called legal business, Ukrainian and international, partners of law firms, and we also included into this work group representatives of our clients, of the law firms, international law firms, and strictly Ukrainian ones. The participation was completely equal from the very beginning to the very end. The clients and the lawyers worked on the same page in order to make the lawyers' work better, to improve the relationships between the clients and the lawyers and all of the players at this market. Next, we listed the so-called pains, the problems in the work of a lawyer with his client. Andrei will be back with us soon. He has to re-enter the meeting. So we were collecting information on what are the problems, the pains for the lawyers, for their clients, for the state authorities when they work with the lawyers, come in contact with the lawyers, the interns, the law students, what were the pains for all of them? What was bothering them was a matter of their concern. And the most popular ones, the most realistic ones, the most pressing ones, we brought together in a list. They are all unresolved, still remain unresolved, and the code, the ethical code, is one of the ways to solve them. And based on the list of these pains and based on the regulation that was already in place, we were trying to address these existing problems by adopting norms that are not still regulated in the existing rules. We understand very well that the activity of the bar is not only legal businesses. The members of our bar association are also members of the private sector, of the state sector, of the corporate world, of the law firms that work with LLCs, other smaller bar associations, and legal experts in all fields. And they all are regulated by certain rules inside their smaller parts of industry. They're smaller niches. They have their own rules and procedures that they must abide by. And this was also taken into account when we were preparing the code. Next, we spent another 18 months writing this code, drafting it. We brought together, we had several rounds of feedback for this code. The draft that is now made public is the one that we finalized after the first round of the feedback after our colleagues. Next, we received the second round after the board of our association, but we didn't share that draft yet because we want to hear feedback from all of you present here today. We're very grateful to everyone who already sent their recommendations. We're especially grateful to people who sent their comments of criticism alongside with suggestions of how to fix the thing that is wrong, amendment of a paragraph, wording of the paragraph, and so on. After today's discussion that we're having right now, after the discussion in the work group, based on the feedback we are receiving from you today, in a spoken form or in written form. If you wanted to share your comments, you can send it to us, send it to our secretariat. I really encourage you to do this by the end of Tuesday, next week. And we will definitely pay close attention to all of your comments in the work group and with the board. It will finally vote for approval of the ethical code before it is brought to the attention of the assembly for voting. This is our methodology of work. Olga, thank you for supporting me here. I don't know what the technical glitch was about, but I'm back here and you hear me. There's nothing else I could add to your intro. I will only say that the work was even longer than 18 months. The first working group that was created started even earlier, even before the task was very difficult, and there was an emergency break in their work because of the full-scale invasion of that began in early 2022. But they resumed their work in several months, so we're grateful to them too. And we tried to take into account the paragraphs of the European Ethical Code of the European Bar Association, and we tried to stand by the key standards of honesty, justice, equality, and professionalism. So I'm giving the floor back to you, and let's get to the essence of it. Oh, another couple of words about what this code regulates, for whom it is, why we decided to suggest to our colleagues to vote to regulate this sphere, and why we think that this is the most relevant and up-to-date task as of now. Here at the association, we have the rules dated 2012 that are very generalistic and are obligatory for all of the members of the Ukrainian Bar Association, all of the members. These rules cover the lawyers, the attorneys, the ones who practice as legal advisors at various enterprises. These rules apply to the scientists, to the academic circles, to the state management circles, to everyone who are members of the Bar Association. These are working and effective rules. It's a good set of rules. We think the only thing that they lack is being more specific. These rules are very general. I think we should add more detail to the regulation of every group of professions that the association brings together. We saw that the category of lawyers that who work in law firms or gives services otherwise and do not have the status of a bar professional is not regulated at all. No regulation about a lawyer, the legal form that is an LLC. There's no regulation of that. And this creates a large field for professional abuse, unclarity. Nobody knows the entire set of the rules of the game. And very often it's it just relies on the internal opinion of the head of the firm, who just takes the entire responsibility for their decision in a difficult matter and a disputable matter, especially when it comes to projects with international companies. This is not acceptable. There should be an obligatory set of rules for the members of the association. Sometimes there's a dilemma: should we take on this project? Is it risky? How do we cover and represent the interests of the client in the best way? What to do in the case of a conflict of interests? So there was no specific set of rules for that. Taking up a set of rules that is characteristic for the state sector is very difficult because the challenges are difficult, the spectrum of activity is different, the problems on a daily basis are different between the Bar Association and the state authorities. So what we decided to do is the rules of ethics dated 2012 are still effective, are still exist, still do exist, and the ethical code that we are working on right now will be the additional code that does not conflict the previous ones. So the rules of 2012 are the umbrella rules, and the ethical code for the legal business will be, for the law firms, will be under this umbrella. Next, we will have the ethical code for the in-house lawyers. And next, we will have a specific ethical code for the state authority experts, for the academic circles, professors, and so on. Anything else needed? What will be the relationship between the umbrella code and the additional codes? They should complement each other and shall be in no conflict between each other. When all of these codes become efficient, the umbrella rules will also be revised and they will be made more adequate to the challenges and demands of today. That is all about the regulation and our further steps. The next thing I'd like to comment is the compliance with these rules, or the obligation to how do you ensure compliance with these ethical rules that we suggest. Right now, the Bar Association has the mechanism to ensure this compliance, to make it obligatory. This is the ethical committee and the procedure of the ethical committee that handles and manages the complaints and any other applications concerning the compliance with the code. Without the authority of the regulator, without regulating the profession from the side of the state, we can only enforce these rules with our own powers in the committee. But everyone has been striving, aspiring to have this ethical code for a long time. We tried to make it's in the best interest of everyone. We tried to make the code understandable, easy, applicable for every and each one of us.
The lawmaking or norm-making activity of the Ethics Commission subsequent to consideration of complaints received would be a key mechanism to ensure that these rules are enforced. The only enforcement measures that we can put in place is a warning or a termination membership at the Ukrainian Bar Association. This code stipulates joining, including by signing a joining declaration. So we have individual membership. However, if a legal company would like to say that it has joined these rules and lives by them, it may do so by that declaration. And also, we discussed the possibility to assign a certain logo for a legal business sector player could make use of and show that it lives by the rules of the ethical code. And probably the last point that I would like to clarify as part of the first block is the methodology and ideology of the code using which it was written and hopefully will be implemented. We tried to make a step away from pure legalizing and regulating all things that are quite apparent in their own right. We try to make these rules some sort of a Hammurabi code, a high-level regulation that stipulates that during a decision making process, a lawyer would undertake some internal work and come up with certain criteria so that they could make their own subjective decision on how to act in a given situation, so that I could consider and could say that I fulfilled those rules and norms stipulated by the code. So as for specific saying what a given person is to do in a given situation, they're absent. So there are criteria and a path to take in order to make the services provision process as ethical and transparent as possible. That's the first block, and I don't know whether there are any add-ons. Please, Andrei. So shall we take comments and questions, please? Maybe someone has an opinion that it should be done differently. Here, I would like to comment. Please feel free to unmute yourself and voice out, or you can put them down in the chat box and then we will read to them and comment on them. All right, thank you. Then I suggest that we open up the code as long as we have no questions or comments to the intro. I suggest that the colleagues ask questions on the provisions that we will be going through in a live way. So it's not a public presentation because the code has not been adopted yet, and you have a unique possibility to make sure that the changes are introduced as we hopefully will see that the code will work for the benefit of all of us. So as for the explanatory note, probably we will not be discussing it as long as it is not part of the document. It is just for our today's communication and for those people who are reading and commenting. All right, so are there any questions, comments, proposals as far as the terms and definitions are concerned? All right, let me say a couple of words here. Colleagues, please feel free to jump in. So the code regulates a legal business. And as for a barrister, we tried to make a lawyer a notion that it incorporates all people that provide legal services. So we are making use of the terms lawyer and services throughout the document pretty much in order to make it clear what is the scope of regulation. Any comments, questions, please? So we do have the chat box, but where is it? The chat box is available and accessible, but no questions or comments so far in the chat, and no hands raised either. So we may move on. Yes, let's move on. As part of our approach to the rules as a matter of the Hammurabi code, we believe that this is the most important part of the document, and believe that this preamble is such a core part, and all issues not addressed elsewhere could be tackled by reference to the preamble for the people to understand what was the purpose of our writing this code. Thank you. General provisions. Here, the key, especially so for barristers, for notaries, and public servants who already enjoy their own regulation, which is mandatory, the core clause would be 1.2, where we give a preference to professional regulation, which is already in place or may be in place in the future for different categories. And the clause number 1.3 is quite interesting. We try to step away from some formalized approaches, and we clearly understand that relationship between the lawyer and the client may be regulated in dozens of ways, and we would like this code to be applicable irrespective of how creative the lawyer and the client were to address the relationship. There's another proposal that you may read out the complete wordings of the clauses so that our interpreters could interpret that, and then our colleagues, our foreign experts could make use of that. So the next one is probably the most interesting section of our code. So the agenda of the conflict of interest is probably the most prominent in the lawyers' work and also in their clients. The Ukrainian legal market is not so large, and as for players in the market, especially so large ones, there are not affluent, there are not so many of them, and there is a seduction that people may undertake some projects that shouldn't have been undertaken given the conflict of interests. And the rules of the barrister's ethics and the bar law are the only means to regulate these matters, and we believe that this regulation is in place. It is in effect, but it does not provide answers to so many questions that have risen in the recent years and even before that. So we try to make sure that the matter of the conflict of interest be addressed in the safest and most transparent way for the lawyer and for the client. And I can see now that there is a comment on the previous clause. So that's clause point 2.2. It is doubtful that there's a term acquaintance, because probably all members of the Ukrainian Bar Association have acquaintances with each other. And also here I should read out that the conflict of interest is also a conflict between the professional obligations of the lawyer and their private interests, under which the following should be understood: the lawyer's own interest, those of their family members, relatives, friends, and acquaintances, and then sub clause 2.2.2, interests of the legal entity and or an entity without the status of a legal entity. Yes, I appreciate what is meant here. Yes, in terms of those acquaintances, it's an important comment. We will take a note of that. Uh, but we here understand that it's a matter of how close people are. Because sometimes it could be just an acquaintance, but still it could be conflict of interest, and it is important, I guess, for the lawyer to determine for themselves whether there would be conflict of interest with that acquaintance would be something uh, in, in place based on a given situation. So can I please follow um, on acquaintances? We looked into how this is regulated in other jurisdictions. So the things called friendships are covered. So we do not say that any acquaintance or any friend is the one that has a common interest with us. But I don't think that there is any sense in limiting that circle with relatives and family members. And there are some explanations that we can hardly differentiate friends and acquaintances. So we just have to look into the essence of the matter, whether those interests are conflicting or not. We just need to understand whether our acquaintance, whether a close good one or not, is the one that receives an advantage. Yes, there is indeed there is a proposal to define the um, word interest. No, we don't want to do that. We don't want to have too many terms and definitions. Not to overdo these codes with legal things. And we all are aware what interests are. In some cases, they would be more important, in others less important. We can, of course, consider now a theoretical situation, and of course, some people had similar cases, and now we can pick up a real life situation and figure that out. But I'm just wondering whether anyone would like to share such a case for us to consider. Okay, just then believe that the word mate would better reflect the essence here instead of acquaintance. Okay, then we will take a note of that. In fact, in this section, we tried to address both situations. First is when a new interest approaches the lawyer or the old one with a new project, and the lawyer is obliged to check whether there is a conflict of interest, and then it may be found out at a later stage that there are some circumstances and that could be discovered after the services have been started. So we address it too in clause 2.4. If the lawyer found a conflict of interest at the stage of services provision, then that lawyer urgently or immediately informs about that all clients whose interest the conflict has risen in relation to, and to terminate the provision of the services to the client when those services have already been started as part of the case. So there has been no regulation in Ukraine for these cases, and before that we could only have some internal thinkings that could be used to address that. But it's here that the lawyer who has started working with the client even earlier gets the chance to terminate the provision of the services to the client. Uh, so this is incorporated here, especially when the legal office can't determine such a conflict of interest in advance in the beginning. And of course, there is no law norm here. It's just a regulation within the ethical code. And yes, here we specify that the client in relation to whom the conflict of interest has arisen may demand the compensation of losses by the lawyer, and there are relevant provisions of the civil code, some of which could be used, but not all of them, of course. We also proposed an option when the lawyer and the client may agree to services provision in the presence of the conflict of interest when there is a so-called waiver on the conflict of interests in writing. But we wanted that the client's interests be still protected, for us not to have the situation when the lawyer says, well, it's nothing extraordinary, you know, I represent your interests and also those of another party, and that's going to be all right. So we spelled these clauses to point 6 to point 7 to point 8, which in their totality are needed for the conflict of interest not to interfere with the provision of the services. And this includes the client being informed, being a person realizing what would be consequences, what would be aftermaths of that situation, and the lawyer should inform the client about that. And of course, that possibility should not be at odds with Ukrainian legislation. There are several norms in the codes of Ukraine, and also there are certain rules on the conflict of interests for the barristers' activities and so on, and they still have to be abided by even in this situation. As for other clauses and things that need to be explained, or maybe you would like to add something. Yes, of course, an artificial conflict of interest. This is one of the largest problem agenda in the legal business, which is hardly regulated anywhere.
The so-called artificial conflict of interest is an issue that is not regulated at all. It happens in cases of large resonance. For example, receive a memorandum on the trial to avoid another party of the trial to ever hire the certain attorney to represent him at this law case, this lawsuit. Of course, this artificial conflict of interest, this is an explanatory norm. This is a norm that exists for education. We need to make it known that such behavior from the client is inappropriate, unacceptable. It's artificial, and we suggest a mechanism how to solve this issue and what should the attorney do in that case to avoid suffering from such bad behaviors of the client. As the client are just as often just as frequent to act poorly. So we have a mechanism of paragraph 2.11 that there's a reason to think that the client has artificially created a conflict of interest, and the lawyer shall immediately inform the client of that and to give the proper justification of why he thinks that. Without such a justification, the conflict of interest shall not be considered artificial. So the lawyer cannot say, oh, you have hired me just to get the memorandum. There should be justifications and argumentative support. If the lawyer thinks that there was a breach from a violation from the side of the client, he should justify the claim about that. For the client, if he disagrees with such claim, he can file a complaint against that lawyer to the ethical committee as well. The industry conflict, the conflict within the industry, for example, in the telecommunication, tobacco industry, pharmaceutical industry, in trial cases between the large players of the certain particular industry. The lawyers who work with these big players are also few, and the lawyers usually want to limit the ability of their colleagues to work for certain clients, and they want to gatekeep these clients from all of the other colleagues. We, as a representative of the legal community, of the Bar Association, we think it has a negative impact on the lawyers and the clients as well. The lawyers lose the chance to build up their expertise on this market and this industry, and they lose the chance to improve the quality of their services for all of their clients, not only for one of the big players of a certain market. So the industry conflict, the conflicts within the certain industry compromise the quality of legal services granted on this market. Also, we are introducing and discussing the new for Ukraine, the payment for the legal services by giving the share in the business. So the fee would be investing by the lawyer into the business of the client. Now, this is a form of payment, a form of fee that becomes increasingly popular, and we think that it can potentially create a personal conflict of interest when the lawyers amongst themselves, when the lawyer basically depends on the well-being of the company, and so the share is so large that the lawyer can develop a conflict of interest, and this can hurt their bias and transparency of his work. You can see the comment in the chat from one of our participants, from Roman. We've been studying your comments. I'm grateful for all of your comments. We've been studying them, and to this paragraph 2.14.4, we're not sure whether we want to keep this paragraph still or not. We would like to hear feedback from other colleagues as well. So this is about investment from the lawyers into the business of the client is acceptable with certain conditions, with certain circumstances. One of them is the investment of the lawyer into the business of the client is not significant for both the lawyer and the client. So the lawyer shall not be directly dependent on the activity of the company and vice versa. So there is a parity and a certain freedom of a professional activity, and the fact that this investment is existing does not define the professional advice of the lawyer. So the lawyer does not work solely to save his or her investment. So this is not like a universally significant, all defining investment. No, this should be, of course, it is the word non-significant requires further clarification. We would not like to be draconian and put detail right now for that. For the company Sienko, Harenko, or Astros, for the giants of the Ukrainian law firms, significance of the fee is defined on one level. For a small law firm, significance means completely different things. You know, if we're talking about like two law school graduates in the province of Ukraine, a significant investment it will be considered completely different shares. So it's up to the wholesome attitude of the legal specialists to define, is it significant for them or not? So any of the colleagues, do you have anything to say here? Yes, there. Sometimes I'm reading out the comment. There are sometimes cases when I must give advice that it's prohibited by the law, but the business really wants to do something and they're ready to tolerate the risk. They're willing to do this, and they want the lawyer to say the risk is acceptable. Mr. Roman, I think that the main thing in formulating this paragraph, the wording of this paragraph, is that would the lawyer use the complicated situation of the client just to get the share in the charter capital of the client, in the share capital, so that they do not take advantage of the client. This should not be about corruption and the attempts to solve the situation illegally. If not, if everything is clear, the lawyer should not be refused the right to purchase the share if they're not taking advantage of the client, especially in the criminal lawsuits. If we're talking about the selecting of the preventative measures, there is a danger that the lawyer would be trying to take advantage on the difficult emotional state of the client, for example. If there is no such professional abuse taking place, I think purchasing the share of the company is acceptable. All right, thank you for this comment. We'll take it into account. And if I may, I would like also to comment that we're talking about not only the the ethics of the payment, using the share of the company as the payment. It's also about the possible conflict of interest. If the lawyer is a shareholder at the client's business, he might act not in the interests of the client, but in his own interests. For example, if it's more profitable for him to have this enterprise to be eliminated, liquidated, dissolved, and the lawyer would get his share in cash, he might act harmfully towards the business. That's an opportunity. That's a danger. Also, sometimes in attempts to protect his investment, the lawyer might misinform the management of the company, the owner of the company, about what should be done and what should not, because he will be caring more about his investment and not that much about the possible criminal consequences for his clients. So here, I think we're talking about the personal interest and the conflict of interests that that derives from that, because there is a bias automatic that is related to being financially involved. If we're talking about insignificant investment, because of this category of insignificance, of course, it's insignificant related to the financial circumstances of the client. Of course, for someone, a significant sum will be 1,000 hryvnias, for the others, 1,000,000 hryvnias. For some, it will be 10%, for some 50%. But the ethical committee that will be applying these rules and interpreting these rules, they will be taking into account this factor and all of the other factors to see was the investment significant or not, and could it influence the actions of the lawyer and their professional activity. We have several comments on the chat with a proposal to eliminate paragraph 2.14.4. Would you please comment on that, those who suggested this? You're saying that it is in contradiction with 9.1. 9.1. Free definition, the freedom of defining the amount of the payment, the amount of the fee received by the lawyer, unless I see that this might generate a conflict of interest. All right, we'll put a note on this and discuss eliminating 2.14.4. I can see another conflict interest issue from Sergey. Is there a regulation of the conflict of interest if the client is a shareholder at several companies? I will start to respond. Andrei and Igor might add to anything I might say. I would comment that that paragraph 2.14.4 there is no cumulative. If we're talking about paragraph 2.14.4, there will not be a conflict of interest. What do you mean by that? Would you please specify? Dear colleagues, I mean that during the representation of the client, the lawyer, if the lawyer will consequently work with the counterpart, there will be a conflict. We are not about a client specific, and we are about the matter specific approach. So the case specific approach, specific issue. So the conflict of interest will be defined on a case specific approach, not a client specific approach. There will be no problem because of that. We do not apply the American approach because our market is too small. We've been thinking about this, we've been discussing this a lot with the colleagues inside of our working group. Ukrainian market is too small. We physically cannot comply with the higher standards that can be observed in other countries, developed countries, for example, in the US. Thank you, Vadim, for your comment. Concerning the conflict of interest, are there any other questions? I can see the comments about eliminating. All right. Next, I suggest we go over to confidentiality. It's not as painful of an issue, but if you had this problem, you know you had it. It's still a big chunk of problems, no standards of confidentiality at all. Everyone does whatever they feel fit, best for their client, hopefully not for themselves. We aimed to protect the clients with this, most of all. There was a comment from Roman or somebody else that we need a positive duty of the lawyer to include into the contract the paragraphs about confidentiality, because they are not always there, and there is no legal obligation to include this paragraph into the contract. Paragraph 3.4 says that the lawyer makes sure that the conditions of granting services to the client include the confidentiality paragraph, including the expiration date of such obligation. Also, we cover in paragraph 3.3 several exceptions from the rules that they saying that all information that the lawyer receives from the client is confidential. We also added the word by the contract. Confidential information of the client might be disclosed by the lawyer in the case foreseen by the law or by the contract on legal services. For example, the contract might foresee that I, as a client, give my permission to the lawyer to disclose the information, the confidential information to my family, my husband, children, grandma, something like this. This used to be an unregulated situation, all right.
Let's move on a bit, Katerina. Yes, subclause 3.5.2 is an interesting one. It deals with the confidentiality standard. We tried not to regulate it because it is very challenging to regulate a given standard when there is such a great difference in the scope of work and in business, especially given that technologies are developing so fast that, say, in 3 years there will be no written documents, and we will just have pens with all of that on our desks, and that's it. So we suggest that confidential information of my client not worse than the way I, as a lawyer, protect my own confidential information. Yes, it is quite an interesting norm, and I believe it is new even from the perspective of Ukrainian mindset. But we propose approving it and try to live with it for a couple of years, and then see what would be the practice of using it, and whether there would be any complaints from the clients that could be potentially submitted to the ethics committee. Clause 3.7 is also interesting when the lawyer learned about the leak or a threat of the leak of confidential information um, of the client. They immediately get no later than in 48 hours inform thereof the letter uh, explaining all the circumstances in place. This was not regulated at all, and there is a specific norm that protects the client and it gives the client an opportunity to take some actions, to make decisions as to the protection of their confidential information, not just relying on the lawyer. Any comments or proposals on confidentiality, please? Maybe someone has anything. Then let's get down to involvement and engagement with the client. This agenda is very interesting. It's very interesting and diverse. Probably it is more painful for lawyers, or in fact, I'm not sure. Probably it is equally painful for both lawyers and clients. I would like to start off by saying a couple of words on competition. So in Ukraine, competition of the clients is harsh. The market is not large, and non-ethical means quite typical at this very stage of interaction with the client. So it's so diverse. It was even hard to structure this clause. The ways are so creative and people use so diverse approaches that it's hard really to restrict that. And it's challenging to put down a proper framework of regulation and proper principles. But we did give a try. Clause 4.2 is very controversial. So we have the referral fee. That's a commission for the client recommendation. That's a situation when, say, the client comes to me, but I can't take them into my portfolio. So I have no expertise. Everyone is busy in my team. There is a conflict of interest, but still the client needs a lawyer, and I recommend him. And I tell Roman, I'm recommending uh, you to the client. He will come to you, but please pay me a certain percent of the honorarium that you are going to receive from the client. It would be untrue to say that these cases are singular in Ukraine. It is a massive practice, especially from the perspective that the client is not informed thereof. And we had two options to address this situation. The first one was to allow that, yet oblige the lawyer to inform the client before the client makes a decision indeed to approach another lawyer, Roman in my example. And the other option was to forbid those referral fees, to make them at odds with ethics and something acceptable in Ukraine. We had lots of discussions on this subject with the legal councils. And in fact, the standpoint of legal councils is the following. We do not mind this fee, yet we want to be aware of it. Predominantly, they want to be aware of in order not to lose the relationships of trust as well as those with the upcoming potential lawyer, and also to have a sense of where the pricing policy comes from, how that honorarium proposed by another lawyer is developed. So we keep on collecting opinions in this regard. If someone wants to comment, we will be very happy to hear from them. But we are more inclined to the first option of this clause. The lawyer may cooperate with third parties on the compensation basis. For example, the uh, commission fee, the referral fee, and, and so on, for the purpose of involving a specific client, provided that the client has been informed about that compensation basis before making a decision by the client on mm, engaging the relevant lawyer. If the client is not informed duly, then the lawyer is prohibited from making such payments to third parties. And that it is not mandatory to disclose a cooperation of the lawyer with advertisement companies, PR agencies, and so on. Well, there's a comment. So the lawyer will not be ethical with all third parties. Probably it will not be ethical to share that fee with some officers, officials, and so on. And maybe it would be appropriate to clarify this item. You know, otherwise it may look as a cut. You know, this is an illegitimate reward that is given to a third party. When it is gearing the client towards a decision in favor of that other lawyer or something. So as for barristers, maybe you have other and larger practices. But based on my practice, it is more about mutual recommendations. It's not really referral fees. I don't know, maybe some other barristers would have different arrangements and they can tell more. But I believe that when a barrister has work, it would not be for him to undertake those fees. Well, in fact, we are not addressing the sharing of the honorarium. We are referring to the referral fee. It's again, it's not about sharing a honorarium. It's that I pay a referral fee to another lawyer, and the amount is identified as a percent of the amount due to be received from the client. So we do not perceive that this forms part of honorarium. As for payments to a legal counsel, the client is approaching the lawyer, it is a total and absolute crime. It's just a cut, it's illegal, and of course it is not covered here, but it's a totally different category, and naturally it is not allowed here under. Well, maybe you would like to ask a question or add something, Ihor. Indeed, when we are referring to the fee, so we are losing you. There are troubles with connections. So we are losing connection with you. Can you please try to switch off your video? Can you hear me better now? Right. So in the law on protection from competition, which is not fair, uh, there are specific violations. when there's this sort of sharing. So we consider that when there is a project in a legal company, the company would want to receive a reward as a fixed amount or as a percentage, and it is of course desirable that the client should be informed about that, because otherwise a lawyer or an investment bank will have it is idea of giving it not to the best lawyer, but to the one that gives the largest fee, referral fee. Yes, that would make sure that the client makes an informed decision, uh, so that the client could understand that this recommendation is for free or for some fee, whether it implies some options or it has no options implied. And then the client would be in a better stance to see whether the lawyer was acting according to uh, the client's best interest. Your connection is quite poor, even with no video, but we heard almost everything. Should there be an obligation for the third party to provide an evidence that the client has been informed about that fee? So from my reading of the wording, it is stipulated. The amount of the fee is not disclosed. There should be the client's consent in any case. But I don't quite understand your comment that deals with sharing something for the discussion with the members of the board. So Olena had the question. Apologies, Olena. Thank you, Olha. Olha. So my first question um, dealt with the core costs for the occurrence of this clause. So I heard from Igor that the client may be referred to people who are not that competent. So that's what I heard. But were there any other reasons? And then I would comment. Well, as a rule, you try to hand over the client to a lawyer in a way that you would be certain and calm that other lawyer will run the client's case well. But sometimes the lawyers are guided by other things. So when Roman pays me a fee, uh, then I will not uh, be dealing with understanding whether Roman has qualification to deal with antitrust matters um, or not. So that's could be the case. And then I will not hand over the client to another lawyer who is qualified, but they don't give me the fee. So as we discussed at the beginning, what I'm doing as part of my practice, when I have colleagues whom I fully trust and I know that they are experts in their field, of course, I will recommend them to my clients. So I have some referral relations with some colleagues, no such relationships with others. It depends, but uh, it is important perhaps to spell out in this clause that when the objective is just enrichment on the basis of some business links and so on, that should be prohibited. Otherwise, it is a good initiative. In fact, there are different things on the market, and the lawyer is always asked by the client or who they would recommend for some other field of legal matters when there are good established relationships between them. I believe it is a matter of spreading out some contacts even without a referral fee, but when the lawyers still go for the referral fee, it is also welcomed. Thank you for that. We will give it a thought. The only thing that I have on my mind, how to determine find the purpose or objective that it was about enriching and not giving the best candidate. I believe that when we exclude the client from this process, it's not quite right. If I were in the client's shoes, I would love to know that, and then knowing that, I would check additionally two things. First, I would check whether that lawyer is really cool, and if the amount of that fee is adequate no, or the fee is added, and then the amount is artificially inflated for the lawyer to get richer. So I have another follow-on question. When there is no increase in honorarium, so the barrister or lawyer gives legal assistance and then just deducts a certain amount from his paid to the recommending lawyer. So without that extra top up to the amount. And here again, the client may decide for themselves whom to go to. So when the client hears that there are some relationships between lawyers, the client should still double check that other lawyer. But okay, when the client doesn't hear that there are some relationships between the two lawyers, then what? Should the client not um, verify and double check? No, the clients do want to get this disclosure and this information. Okay, so it's based on some prior practices. I see. Then clause 4.4. That's an interesting one. So we have extremely different opinions here. So we have some groups of colleagues who say we will not delve into personal relationships between the client and the lawyer. And there's another category of people who say that the entire world is actually following this path. It should not be allowed because it does have an impact on the quality of services and so on and so forth. And that's clause 4.4. So do we still have interpretation on? Yes, indeed. As long as I understand, we still have some time. So let me read here. The lawyer shall not enter into sexual relations with the client. The lawyer may provide the services to the client with whom the relationship of a sexual nature began before the provision of the services with some conditions. That this clause was not in place in the initial wording, but a person who was providing his or her feedback as part of the first circle of discussions suggested this. I believe that it still needs to be discussed, and if there is a will of all stakeholders, we should add this clause. Yes, there is a comment in the chat box that this clause needs to be preserved, but would anyone want to say something in this regard? Olena.
I'm a family attorney, and I also had a lot of a discussion with my colleagues inside the company. I know that on the example of my colleagues in the sphere of criminal law and in the family law too, when these disputes can go on for years, And the situations are different. Sometimes during this time, a family is formed, and shall the person choose between family and acting as a and work? Yes, I think this is about sexual harassment. This is to prevent sexual harassment or abuse or a threat of psychological pressure. I know what is this about, but if we are talking about this point generally, I think it will not work, because if we comply with this completely, it seems that at some point you will be forced to make a choice, personal life or professional life, and lose the opportunity to give grant competent legal assistance to a person who needs it. During a long period of time, the client and the lawyer can even form a family. Of course, it's difficult. For example, the client and the lawyer were not in matrimony before they started working, and then they started working together on a law case, on a lawsuit, and then they became a family eventually. Why do we need this paragraph? What is the preventative force here? Thank you. I will answer here. We had discussions about the matter of family, and generally in foreign countries, this is solved abroad with the zero prohibition to give to grant the services to the members of your family. This applies to situations when the relationships began after the beginning of the professional cooperation, and this is to protect the client and to avoid influencing the way the client is protected. This is a way to protect the client from the possible abuse from the lawyer. This is why we introduced this norm. I completely support such prohibition. From the ethical side, our society lacks a certain understanding of separating the professional and the personal relationships. Is completely unprofessional in my point of view, in my opinion, to have personal relationships with the client. If it's your girlfriend, if it's your wife, you can't be impartial, because practice shows that the data you get is confidential, and also the relationship can go in different directions between the client and the lawyer. Later, if the relationship is broken, the lawyer can use this information against the client. If it's about a psychologist, if you use the professional services of your therapist, you cannot be in a sexual relationship with them. Same thing with the lawyer, same thing with the attorney. We're talking about professional assistance, moral support, and so on. It's completely unprofessional, I think. It's even out of discussion here, I think. You need to choose. That's true. If you like your client as a male or as a female, personally, romantically, you can choose them as your partner, but then refuse to grant legal services to them. I completely support this paragraph. All right, let's proceed. 4.6. I turn everyone's attention if if it jumped out of the scope of your attention. Let's talk about it now. If the lawyer found out that the client has an unpaid fee to other lawyers for their services, the lawyer can refuse from granting his services to the client, including with the justification of that decision. This is a completely new paragraph, completely new regulation. And this is up to the lawyer to start asking yourself questions before taking on the new client. This is the obligation of the lawyer to protect themselves from, because if there is history of non-payment, this might happen to the new lawyer too. This is a painful paragraph because it's sensitive. There are clients who start working with one client, with one lawyer, get a big chunk of work done and build their steps within the project, and then use the work of another lawyer and do the same without payment. If we try to solve this, we might try to solve this based on the behavior of the lawyer. And the lawyers should support each other and like sometimes refuse to work with the clients if they're not paying them, if they're not paying the lawyers. We had a regulatory procedure who informs what based on the confidentiality and so on. We started with the point with paragraph 4.6 and getting the result, whether it will work, whether it will change anything, or whether it will improve the level of respect from the clients to the lawyer, and the respect within the lawyers community, between themselves, between the experts. I love this paragraph, honestly, and I really hope that it stays here. It stays in the final draft. I don't see any more new comments, so we have several paragraphs that relate to. Oh, we have a question in the comments. Can you please explain how do you explain the how do you withhold the amount of the fee if there's a commission? Well, but disclosing the information shall first be run by the clients. First, I ask for permission of the client to recommend somebody on a paid basis for a fee, and then and of course automatically the payment is disclosed. Concerning 4.6, 4.8, 4.9, what happens then? These situations are very frequent in crisis periods. When the companies transform, the people take different paths in their professional life, and the destiny of the clients is not resolved. We suggest to regulate it based on full transparency to the client. For example, saying like, all right, we stay at the company, we leave. What qualification do both sides have? Will you be able to support the client after we you part ways? It will be a chance to tell the client what services you can keep giving, on what basis, and given the chance to choose who to keep working with. And thank you for your comment. Termination of the services, granting the services to the clients. Of course, it's not a particularly problematic number of issues, but still, there are questions that arise We would like the interests of the client, in this case, to be protected. We would like normal, transparent transmittal of information to happen, to avoid any leaks of information or damage or loss for the client. Avoiding corruption. This seems self-explanatory at the first sight. It's very expected. Everyone is obliged to work honestly within the framework of the law and avoid corruption, of course. Paragraph 5.2. The lawyer shall terminate his services in the lawsuit in the case if continuing to give such services will lead to a conflict of interest, breach of compliance and integrity, or other laws or other rules. We have a comment that the formulation, the wording other rules is very vague. This is a standard wording. We are talking about the norms of the law. It's a very standard one, I hope. So, Igor has raised a hand. Yes, colleagues, I have a comment that we do not limit ourselves with the rules because we have an ethical code and our principles of compliance, integrity, and so on are sufficient to terminate these services. Next, we'll have other comments on countering corruption that we are using in an interchangeable way of the right and the obligation. But ethics demands to stop these conflicts of interest if we want to ethically stay in the profession. All right. Thank you, Igor, for this comment. So countering corruption, we have legislative base. We have a lot of regulation on this. We as lawyers are especially responsible to the society. We think that we must be the pioneers in the compliant behavior. So it will never be too much. It will never be over the board to insist on the compliance with these norms. We must be the moral compasses in this case. In this sphere, there are a lot of corruption risks in our work. We work all the time with the state organs. We are the professionals that people come to and ask to solve the issues and their issues, and we are responsible for stopping from the very beginning any attempts like that. So we think it's obligatory to have these norms. These norms should be here. We have a controversial norm suggested in paragraph 6.3, where we're talking about informing about the data about the work of other lawyers where we see signs of corruption. We would like it to stay. Maybe you, the colleagues, we can comment on what do you think of this. It's not about the relationship of the lawyer and the clients. It's about another lawyer, the behavior of another lawyer, the client. So there's no issue about confidentiality, but we do have an issue here with possible abuse from the side of lawyers to their uh, competitors, and there should always be balance. We have another part that says about the work with their colleagues, with their counterparts and competitors. There should be a balance. The norms that should prevent violations so that they are not used in an inappropriate way. This is a bold norm. It will be great if it is included in the final draft of the document, because the work of the lawyer in Ukrainian legislative base is not regulated legally. Um, right now, I am on the final stage of my PhD on the legislative gaps in the client-lawyer relationship, and this is exactly what I'm studying. Will some lawyers use such norms in bad faith to harm their competitors, to make certain information public in order to harm their competitors? I think the industry will lose from this. There will be a lot of reputational loss. I think such unethical attempts to compete will be eradicated. Our market is already losing this attitude, so I'm completely happy to see these developments. All right, let's go further to public communication. This is generally about the ways to work for the lawyers, ways of lead activity, to be competitive, to be respectful towards one another. And all of this combines to the with the opportunity to criticize and to have the healthy way to develop the industry. If you're not a speaker, please mute yourselves. Thank you. All right, next. We're seeing many examples of so-called black PR, where the competitors order entire companies to be badmouthed in the press, information anti-campaigns against their competitors, against their rivals. But we would like to keep the opportunity to give your judgment with this, maybe even develop this, and improve the professional capacities of other lawyers.
It is important to understand whether given a criticism is for the better or to cause harm. So we try to spell it out the way it is now shown, and also an interesting norm contained in clause 7.4, when the lawyer identifies themselves with the client. We see cases when these things happen, whether initiated by the lawyer or by the client. However, the fact of the lawyer's representation of the client should not in itself mean that the lawyer is identified with the client. And then a very important section that deals with interaction with the staff, with the team. It deals with complex work conditions. We are all aware of our work under such pressure and in those hours, and how it all impacts not only the lives of our people, but also the quality of work. So we believe that this clause requires attention, and that the lawyers need to pay attention to this clause in the years to come, including after the war. And we call you to define what's best for yourself, for your team, and make sure that there is a possibility to work with dignity. Katerina, you can go on. I just wanted to comment the word personnel or staff. Um, can see it in the name of the clause no, because it doesn't resonate with me well, and I can see that employees throughout the text elsewhere. Uh, so maybe stick to the employees. Indeed, thank you, Katerina, for this remark on the term which is defined in our document at the beginning. Clause 8.4. So competition for talent. So our legal environment is where there are debates. All right, thank you. So there are ongoing debates regarding the competition for talents, whether it is in place or not. Okay, let me finish off 8.5 and then I will come back to 8.1. So it is all about the right or no right of legal companies to seek and hire and poach employees. So we believe it is important to enshrine the possibility to uh, go after talents, and thus we will basically answer the question of whether agreements are allowed between the employer and the employee. We believe that this is not admissible, and we have to provide opportunities for employees and administrative teams to develop themselves and so on. So there was a question on 8.1. What is it meant by the wording unless otherwise follows from the nature of the relationship? So it is all based on the labor legislation, and then the text goes unless otherwise follows from the nature of the relationship. So I do not remember what was meant here. Andrei, maybe you would know. Maybe it was meant that we try to cover not only labor legislation, but also when there are private entrepreneurs who in fact perform functions that are close to those of the employee that still needs to be covered uh, in order to make it impossible to evade from the clause. So, for example, when we have a civil law contract with our employees, instead of employing our people to cover that all, but maybe we should state here that making use of private entrepreneurs is not ethical. So maybe we should specify that, and the normal lawyers do not have that, because we are speaking about some high level things, but we are not basing our chat on this simple one, but it is present elsewhere above as part of this structure. Yes, and here when we have a labor or civil law contract, and we have a daily going to office, some holidays that are paid for, and so on and so forth, that should be employment. But there are still some cases when it is all about contract-based relationships, and this is not employment. Yes, indeed. Following the question in the chat, it is about being non-ethical when we do not pay taxes compared to clean white businesses that hire employees as employees and pays taxes, and then the employees are protected under labor legislation, as opposed to tax evasion, deviation, and so on. It was important for us to note the broadest possible list of possible options for honoraria, so that liberty could be in place in decision making. So we try to spell out this clause, this entire section, from the perspective of sharing information with colleagues in terms of what different options are. And maybe some people would like to make use of that. Maybe there is a mixed payment, or there is an average weighted fee rate. All these options have their right for life, and they stimulate the development of business and encourage competition. Also, we try to regulate the matter of misuse when payments are made on the basis of hourly rates, for lawyers to calculate hours in an integrity manner. So we share some practices. We talk about some practices when the number of hours is inflated. So there are some attempts, for example, to present some non-legal work, say administrative one, as if it were legal work, and charge for that. As for the success fee, Andrew, can you please dwell on the success fee? That's close in 9.5. So the the client and the lawyer may agree on the success fee contingent fee, which shall be paid upon achievement of the result agreed with the client, and may be determined as a fixed amount, or as a certain calculation or computation, for example, proportion, percentage, formula, etc., of the amount of the transaction, dispute, property value, etc. So we are aspiring to regulate this matter, which is so widely discussed in the Korean market, whether it could be in place or not. So we may have this honorarium, in our opinion, and there were lots of debates in this regard. So we agreed to have it in this form. There was a discussion that the success fee may not be applied as part of criminal proceedings, but still the current wording of this provision is as it stands. Roman, can you please follow up? uh, I can't see that this payment is for completed work. Oh no, in fact, there is a definition and explanation that it is for the work done. Clause 9.6, Katerina, can you scroll up? I will read out this clause and explain why it emerged here. So lawyers have to compete with each other honestly and in good faith, including through price competition. And what is not allowed is non-transparent or unfair pricing, such as misleading the client about the fee or the scope of the services offered, deliberate underestimation or deflation of the fee at the initial stage of provision of the services, in the expectation of receiving additional compensation by artificially inflating the fee at subsequent stages. I don't know whether everyone has encountered this sort of situation, but I believe lots of people have heard that very often a way to encourage the client is, in fact, deceiving. It's not just dumping to give the lowest fair price, but it's just deceiving by saying that this work will be done using X funds, which looks unrealistic oftentimes, so that when the client comes along and accepts this proposal, then when there is an active phase of the dispute submission or transaction, and when it is so difficult to switch to another lawyer, the services start costing 10 times more, and the client does not expect that to happen. So we are, of course, discussing this matter as an unacceptable thing. As for business structuring, again, this is one of the most painful matters, especially so in the case of clause 10.2. Let me read it out. Non-compliance, tax evasion, aggressive tax optimization, and creation of other unfair advantages. For example, avoidance of payroll taxation, substitution of labor relations with business ones, as discussed above, unaccounted cash and Katya, can you help me out here? Cryptocurrency denominated fees structured through offshore zones or artificially created multiple legal entities, unauthorized subcontracting, distort the competition and the client's choice. And this is not ethical. I'm just reminding that we have the ethical code, and this is what we are guided by ethical principles. And of course, there are some tax evasion practices, but there is the national legal framework. Yet there are practices to structure it all through offshore jurisdictions, but the question is whether it is appropriate for a legal company to do so through offshore jurisdictions. And it is just as an example about the case when there is the association of lawyers and also limited liability company. So not all lawyers work as barristers, and not all barristers work as lawyers, and not necessarily barristers work in limited companies, and vice versa. And there are hundreds of such cases, and the only objective here is to optimize taxes and not pay taxes to the state. We had the forum on legal services, and I don't know whether anyone of you attended it. We had lots of debates there, and in fact, most legal companies from Ukraine were discussing that, and they confirmed that they would be ready to disclose their organizational structures, that they do not create multiple legal entities. But once again, it is a matter of subjective assessment of whether a certain structure of business legal company is really justified by the client's needs, or it is a matter of offshore jurisdictions and underpayment of taxes. Given that we are somehow pioneering in creating a legal society as development, the structure of business may be part of our way of doing things in this regard. So are there any comments, please? There are comments indeed. So there are comments on tax evasion and tax optimization. Yes, we are aware of this agenda. We reckon that provisions stipulated in clause 10.2 to expect from lawyers that the activity would be on the widest possible terms. On wide terms, we expect that there will be no pro forma approach to running a business and no pro forma approach to taxation, and we expect changes towards transparency. There's a proposal to prohibit the, the motion for the reduction of compensation of expenses on legal assistance. We thank you for this comments, Semen. I believe that it deals with the judiciary processes where one party requests a reduction in legal assistance compensation costs. I don't remember where we wanted to introduce those changes, in which clause. I don't think that we will be writing in that detail, specifically referring to this compensation reduction. However, my colleague today advised that it may relate to the deflation of the value of work of other lawyers, and we may give it a thought as to where to spell it out. Thank you for this valuable comment, and we will keep on ironing out. So we reached the end of the code. So we have a complete section that could be supplemented with things that were not stressed at all, and not regulated at all. Maybe there are some proposals uh, at the moment. So maybe you just give this a thought over the weekend and then write back to us. But we are open to that. We'll be happy to hear from you and address those comments, because we're going to adapt this code for it to last, not just for short-term perspective. Any questions that you would like to discuss? Andrei, Igor, would you like to add on some things, things that I have not mentioned? I would not have anything much to it. We will just discuss this. We will just analyze additionally the comments that we have received today. Indeed, we are writing it down, and we will be addressing all things that we discussed, and all things from the comments in the chat box. So we will also process all things that we will receive from you by Tuesday. Oh, there's a proposal to improve connections between the event participants. And after that, uh, we will submit for approval by the General Assembly a complete entire text. And I agree with the proposal to improve connection. Uh, I would like to thank all the participants for criticism, for comments, feedback, which helped us to improve our work. It was so much important for us, and we are hopeful that we are doing an important and big uh, deal, although this step is quite minor. There is still so many things to be done, but we should start somewhere. And it's my pleasure that we are starting, even though the times are challenging now. And those times actually require even a more fair and just assessment of our activity, of our actions. And I thank you all, colleagues, and hope to see you soon during upcoming meetings.